Welcome to Talk to SWU Live. Great to see so many people here. I'm Callum Gallagher. I work with SWU as Assistant General Secretary. And behind the scenes tonight, we have Sean and Joe. Our focus for this evening is social work regulation and fitness to practice. Before we go on to discuss, I'm going to go through some housekeeping. So firstly, you'll see the questions box towards the top right of your screen. The team behind the scenes are going to make me aware of the questions as these come in. Please be assured this is a safe space where your questions are anonymous. However, you do need to keep them objective so as to maintain your confidentiality and that of others. The event is recorded and it will be available soon to watch and to share with your colleagues. Any advice during the session that's given is current and relevant as of today's date, which is the 18th of November 2024. Before I go on to the important part of introducing our panel for this evening, I want to emphasise to you the importance of joining a trade union as a worker. SWU are a professional trade union for social workers. As a trade union, we offer skilled representation, and beyond that, together alongside our colleagues' professional body, BASW, we offer shared benefits as part of a social work community, providing opportunities for professional development, collectivism, and support. As a specialist in your profession, why would you not want to join a specialist trade union like SWU? Please keep checking the comments box for information on our campaign fund and look at our webpage for recent blogs and activity. I'm going to go on to the important part of the session and I'm going to hand over to the panel members to introduce themselves, starting with Colin. Thank you.
Hello everybody, it's nice to be here, and can I just start by saying I'm working from two screens, so if it looks a bit peculiar that I seem to be staring into the distance at different points, honestly I haven't lost interest, I'm just reading something else or looking at something else. So I'm Colin Anderson, I'm a service manager in the BASW SWU Advice and Representation Team, and I focus particularly in my case and my staff on regulatory work. My colleague who's with me this evening is Laura Sheridan, and I'll let Laura introduce herself when I hand over to her to cover part of the start of this, the introductory part of this. We're going to answer as many questions as we can tonight, but we thought it would be good to give you a quick background context of what we do and what regulation for social workers looks like in the United Kingdom. So I'm going to spend a few minutes looking at the team I manage within BASW SWU and what we do, and then I'll talk a little bit about regulation in the UK and what regulators do in regards to fitness to practice in a broader sense. I'll then hand over to Laura, who will look in a little more detail about what fitness to practice means and how fitness to practice processes work and some of the issues members might encounter. After that, we'll move on to questions. And so as we've only got an hour or so, let's just jump right into that. So in terms of our team and how we've organised our team, until a couple of years ago, the Advice and Representation Service was one team. And it's a bit more than that, about 2.5 years ago, we decided we would have a reorganisation and specialise in broad terms in employment and in fitness to practice. So about 3/4 of the team do mainly employment work, and that's proportionate in relation to the volume of work we deal with, and the rest of the team specialise in doing regulatory work. And the reason that we decided to split the team and specialise in that way is simply the complexity of both employment law and employment work and fitness to practice work. It's increasingly difficult to cover that whole spread. So that was the reason that we decided to specialise, and in practice it's worked very well with a much greater concentration of effort into the two functions. In relation to regulatory work, and that's what we're here for tonight, any eligible member is entitled to support from the beginning of the fitness to practice process, and we're going to talk a little bit about that later, about what we mean by that, right through to the end of the process. And what I would say, and I think Laura's going to encourage this too, is that we frequently get people coming to us quite late in the process. Please, if you have any concerns and you're an eligible member, do approach us early, because it sets the tone for how the process will unfold thereafter. So that's important. Turning now to regulation and the way regulation operates in the UK. There are 4 regulars in each of the UK countries. So we have Social Care Wales, Northern Ireland Social Care Council, the Scottish Social Services Council, and of course Social Work England. Now we're going to talk tonight generically about fitness to practice, but it is important to remember that each regulator has different things they do in addition to fitness to practice. So for an example, in England, the regulator only regulates social workers. In Scotland, the brief is much wider, and they regulate social workers, social care workers, social work students, and they have standards for employers. In Wales and Northern Ireland, they also regulate care workers and students. So it can be a confusing picture, given that each country tends to have its own way of doing things. When it comes to fitness to practice itself, as I say, Laura's going to look at that in a little moment, but it's helpful to remember here that there are some subtle differences too in the way that regulators approach fitness to practice. So, for example, following receipt of referral, some will initially assess before moving to investigation. Others will screen or have a triage system. In reality, that's more about terminology. They're all have an initial sift of the referral that's come in to see whether it warrants going through to an investigation process. They have slight differences further on in the process too, in other parts of the terminology. And so, for example, in Scotland, they have temporary suspension orders or temporary conditional orders, conditional registration orders. In England, the terminology is interim. They use this. It's the same. Essentially, it's the same thing. I can see that there are questions popping up, but I'm going to leave them until I finish this bit, and then I'll have a read of them and come back to them if that's okay. So although we've got these differences, and it's important to recognise there are these subtle differences, overall the process is broadly very similar across the UK. I'm going to hand over to Laura now, but with just one more thing to say. And whilst each of the regulators that I've mentioned in the 4 countries has a different approach, their overarching objectives of each of the regulators is focused upon, 1, protecting the public, and secondly, protecting the reputation of the profession. That's their stated objectives in terms of their fitness to practice programmes. So at this stage, I'm going to hand over to you, Laura, to look at fitness to practice issues. Thanks.
Thanks, Colin. Good evening, everyone. As Colin has already said, I am Laura. I'm one of the Advice and Representation Team, working for BASW and SWU's Advice and Representation Service. I've been around with BASW for about 6.5 years now, and I was one of the people that came over to the regulatory team from day one. Yeah, been around for quite a while, and feel like I can answer hopefully a lot of your questions this evening. So before we move on to questions, I think it's helpful to just give an overview of what regulators do. And the first thing to think about is what the term fitness to practice means. So what do regulators mean when they talk about fitness to practice? And in a nutshell, it means that someone has got the skills, the knowledge, the character, and that they're healthy enough to practice their profession, and that they can practice it safely. and without any restriction on their practice. It isn't just about your conduct within work. It could also include an act by a professional that might actually make the members of the public question that person's conduct, and potentially could damage public confidence in the profession. So your conduct outside of work can also come under question as part of the fitness to practice process. An example, a particular example would be something like a criminal investigation that the regulator would clearly be concerned about, even if that criminal act had happened outside of the workplace or wasn't necessarily related to your conduct at work. So a regulator may, well, there's lots of situations where the regulator might investigate your practice. It could be when they've got concerns about your conduct in the workplace. So it could be if they've got particular concerns about how you've managed a case, for example, or worked with the family, communication, your ability to manage your caseload, that kind of thing. A regulator is particularly concerned if there are questions about somebody's honesty or integrity, and dishonesty is an allegation that tends to attract the most significant sanction if a regulated professional is found to have been dishonest. Criminal convictions, as I've said, would also be something that the regulator would be concerned with. Particular criminal convictions more so than others, but that it should be something that the regulator is notified of. And I think if you are under investigation for any kind of criminal offence, then you need to seek advice from us and probably self-refer to the regulator. Kind of linking into that, if you've been barred from working with vulnerable groups, the regulator needs to know, and they may well put restrictions on your practice themselves. Quite often, and particularly with social workers, we see a service user, or families who you've been working with, for example, making referrals about your conduct. Sometimes the regulator will investigate that depending on the nature of the referral that's come in. Sometimes it doesn't meet the test for them to investigate. Referrals can come from employers, members of the public, as I've said, service users, and sometimes we see referrals coming through from the court. So, for example, coroner's court. A coroner will sometimes refer to a regulator if they've made a finding and they're concerned about someone's conduct. And the regulator is likely to kind of proceed to investigate anything that could bring into question your suitability to practice as a social worker. Now, there is a process that regulators go through when they're investigating someone's fitness to practice. I'm aware we've not got much time tonight, so I'm not going to spend ages going through what to expect throughout the process. I think what I would say is we can talk you through that individually in more detail. There are a few kind of stages in the process that are quite similar regardless of the regulator. So it's helpful for you to know what to expect briefly. So initially a regulator will triage a referral that's been made to them to decide whether it is even something that they need to investigate. They all have kind of tests or criteria that need to be met. If it doesn't meet that criteria, very often the social worker has no idea that anyone's even referred them to the regulator. If they do decide it meets the test, they will then go on to do an investigation, and the social worker will get the opportunity to respond to the investigation that's taken place and any evidence and any investigation report that's been completed. Normally, there is then a process where somebody independent, normally two people, will have a look at that after the investigation and look at the response from the social worker, and then it's determined whether or not a case needs to progress to a hearing, or whether it can be dealt with at that stage, or there's no case to answer. So sometimes, or quite often, we see cases being closed at that stage because there's nothing to support a case progressing to a full hearing. But sometimes cases do go to a hearing, so then we start to see preparations being made for a hearing, and the ultimate final stage of the fitness to practice process is a fitness to practice hearing, where there is a panel of adjudicators, and the social worker the allegations are put to the social worker, witnesses attend very often, and the social worker will then put their case forward at that hearing, and a panel will ultimately make the decision as to whether your fitness to practice is impaired and any sanction that needs to be put in place. I will kind of end my spiel by reiterating what Colin has said. You know, when should you get in touch for advice with regards to fitness to practice? I would say immediately after you've been notified that your regulator is investigating your practice or your conduct. Do not wait and hope that it will go away. Quite often, I think social workers, because regulators quite often take a long time to investigate things, you don't hear anything for a while. I think people often hope that that means nothing's happening. Perhaps it's very, very stressful, very difficult. So sometimes I think people will kind of almost try to avoid it, understandably. But if you ignore it, it is not going to go away. And what I would say to people is regulatory proceedings are very specific. There's a lot of kind of legal background to them, a lot of processes, a lot of the things that regulators are looking for to prove that you are fit to practice. So the sooner you come to us for advice on how to respond to allegations, for us to support you with challenging investigations, that kind of thing, the more likely you are that your case will perhaps end sooner in the process. Not necessarily guaranteed, but ignoring it is more likely to make it end up going further if you haven't provided the right response at the initial stages. So as soon as you hear that you're under investigation, get in touch. We are a nice team of people that understands that sometimes, you know, social workers make mistakes. You know, there is no kind of judgment here. We're just here to support and represent you through the process, because there's such difficult processes to go through. So don't leave it. Please ring as soon as you can.
Okay. Thank you, Laura. I'll move to some of the questions. And so, Colin, I'm going to put this question to you first. Where does a social worker's mental health come into fitness to practice?
Well, that's an interesting question, and I'm not quite sure what angle the question is coming at me at, but I'll answer in two different ways, I think, Callum. There is a situation where people often have, or occasionally have, difficulties, particularly in relation to fitness to practice concerns because of ill health, because of mental ill health. And regulators will take a different approach when the concern is about a capability issue, in essence, a fitness to practice issue because of ill health. So whereas, you know, they immediately would be moved to a process of gathering information and evidence, the focus is going to be on medical evidence if this is about someone's well-being and health. So they will usually use ultimately they will usually use an independent medical assessor, but prior to that, they will often look to get consent from members to get reports from doctors and, you know, existing medical evidence, and they'll base decisions on the extent to which someone is in control of their health and well-being, how well they understand it, and get in control of that. And again, like I said earlier on, and Laura re-emphasised, it's about the protection of the public. So the you know, any decisions that are made are based on, if someone's in control of their health and well-being, there shouldn't be a fitness to practice concern. If they aren't, then those concerns may require some intervention from the regulator. The other angle that I was thinking of in relation to that question, though, is the number of people who have who develop anxiety and mental health and, you know, depression and mental health issues as a result of being referred to the regulator. People will probably be aware, but I'll mention it anyway in case they aren't. But all of the regulators take an awful long time to work through processes. And it's not unusual to have cases running for 3 years. And we have cases running, certainly in England, where there've been particular problems for a good deal longer than 3 years. So, you know, it's not that unusual to see 4, 5, and even 6 years, cases for 6 years, which is deplorable. And that puts immense pressure on people. Now, in terms of what we do about that, you know, we constantly remind the regulator about the extra stresses this places on people. And whilst I would say that all regulators offer sympathetic support, it's not the priority. So you need to be looking for support if you've got mental health issues created by your response to the regulatory system. You need to be looking for support elsewhere. So it's an interesting question. I wasn't sure what the question I had in mind, but that would be my two approaches to that, Cal.
Thanks, Colin. Very, very comprehensive answer. Laura, is there anything you want to add to that?
I think Colin's covered that very well, Callum. To be fair, I don't think I've got anything to add to that one.
Well, I've got a question for you now, Laura. Why isn't SWU recognised as a trade union with local government employers?
That's an interesting question, actually, and I think it's quite important to clarify what is meant by that kind of formal recognition, because I think sometimes employers get confused and give our members the wrong message. So in terms of recognition, what that means is that most employers have certain unions that they choose to be recognised for what we say is collective bargaining purposes. So that is normally when there are restructures happening within an organisation, potential redundancies likely to happen as part of that, potential changes to people's terms and conditions. They have normally one or two recognised trade unions that they specify, the ones that they do those kind of meetings with, that bargaining with, to try and get the best outcome for the unions are obviously there to try and get the best outcome for the staff. Now, there's a difference between that and general recognition. What we tend to see quite often is employers will say, no, you can't bring a SWU rep because they're not recognised by us to, I don't know, a sickness meeting, disciplinary meeting. That is completely wrong. And if your employer is telling you that, that's wrong. You have a legal entitlement to take whatever union rep you want from any union of your choice to those meetings. The recognition is literally for the collective bargaining side of things, not for formal processes. Like disciplinary would be an example of that. You're entitled to take the rep of your choice in. We do occasionally have to challenge that with employers ourselves. We point them to the right area of the law. We'll quote the area of the law. I'm not going to do it now because I don't know it off by heart, but we are very clear that the law says you can take, for individual meetings, you can take a rep of your choice. And I think, particularly when people are at risk of redundancy, whilst with most employers we don't have those kind of collective bargaining rights, we can normally, and I think kind of 9 times out of 10, to be honest, we go to the individual meetings with people. So we'll attend the meetings for the staff member where they're individual, to discuss their individual situation and whether there's going to be any changes to their terms and conditions and what we can do to try and get the best out of them. For that, and I know I've never been refused entry to any of those meetings because it's an individual one, again, where you've got your individual rep. I know that what we are kind of trying to make progress to get those collective bargaining rights within employers, and I am aware that SWU has kind of recently gained those rights, the trade union recognition with Humber North Yorkshire Integrated Care Board. So there are some employers that we're kind of getting in there with those collective bargaining rights. But we are at any union of your choice, like I say, for individual representation, we are perfectly eligible to attend with you, and you are entitled to us to attend with you. So don't be told that, don't accept your employer telling you that we can't attend, because we can.
That's great, Laura. Thank you. Colin, do you want to put anything in there?
Only the reference that Laura was looking for. I've had the benefit of having a quick look on at my computer, and it's Section 10 of the 1999 Employment Relations Act.
He had to show me up, didn't he? I thought he was going to tell us that he knew it off by heart for a second.
Oh, I didn't know it off by heart either, Laura.
I'm going to remember that, Colin, don't worry.
Okay, thank you. Colin, I'm going to put this question to you now. Please advise what powers do SWU and BASW have in supporting a social worker who has been barred from DBS, but fitness to practice from SWE Both public government bodies. Sorry, I've not read that very well. So I get the sense somebody.
Yeah, I
Carry
think
on.
I've got the gist of the question though, Callum. I think someone's asking what we can do to help in situations where they have they've been bored by the DBS, but Social Work England have indicated that their fitness to practice isn't impaired, or that they haven't done anything about that. Just say right off that's an unusual situation, because I would expect in almost all cases I've seen, if someone is subject to being bored by the DBS and Social Work England have become aware of that from whatever source, if they've received a referral from somewhere, they would normally open an investigation. And if someone's barred from the DBS, they would look at the circumstances which led to the barring and take their own independent decision on that. And it's usually a very punitive one, because the DBS is usually based on some serious allegations, some serious prima facie evidence. Strangely though, I did have one just in the last couple of weeks. That was the first one I've seen in 10 years. So I don't know whether this is a trend or whether it's coincidental to the question in relation to someone also making inquiries. So it specifically says, what powers does SWU and BASW have? And we don't have any powers at all in relation to that. What we have done in the past is to help people to understand the DBS system, which is a very punitive, draconian system. They have evidence, and they, for good reason, they've got statutory powers to protect children and vulnerable adults, and they will make decisions that someone isn't, they're going to prevent them from working with those two groups of people for public safety reasons. I think part of the question also says about the fact that there are two government bodies, and it appears that they're saying different things. There's the same issue, but one's saying giving one outcome and the other another outcome. And that's the bit where I would need to know a little bit more about the specific circumstance of that case, because in almost every case I've ever seen, the actions have been not coordinated because they work independently, but they've arrived at the same conclusion. So I, in that sense, it's quite surprising, and I'm not quite sure how it's got to that situation. You could almost wonder whether Social Work England were thinking to themselves, if they've seen someone's barred from the DBS, then do we need to do an investigation? They can't work anyway. But that would be wrong to do that. I think they should be looking at it and arriving at their own conclusion, because it's two separate things, potentially two separate things. So it's an unusual question, and I'm sorry if the answer is not very clear, but I think I would need to know a bit more about the specific circumstances as to how it got to the point that it's got to. I'm not sure, Laura, if you have anything to add to that.
Only to say that the general guidance from, and I'm quoting Social Work England here, but I would assume that most regulators would be the same. The guidance that they have on making a self-referral states that if you've been barred from working with vulnerable groups, you should self-refer to them. And I would say that would be the same with any regulator, regardless of what their guidance says. It would be a point where you should be self-referring to the regulator. So I think there is guidance on Social Work England's website called Safe and Effective Practice Guidance that gives a whole list of when you should self-refer to the regulator. It's quite good guidance, actually, and it does give kind of examples of when you should be self-referring. So it's worth having a look at that if you are in that situation, or if you're in a situation where you're not sure whether you should be telling the regulator. That guidance probably will help you to make a decision one way or the other.
Thank you, Laura. Yes, I can add that there's similar guidance for the SSSC as well. It's also available on their website. Next question is going to come to you, Laura. Can you clarify who is the regulator for our employers in terms of wishing to highlight unsafe working conditions, particularly involving electronic systems? CQC, LGA and SWE do not want to know.
Okay. Well, this is the difficult one because it depends on what area of work you are working in. and also which country you're working in. So, for example, I think there was mention of SWE there, so I'm presuming that this social worker is working in England and has had the conversation with SWE. Social Work England only regulates social workers, so therefore you cannot refer your employer to Social Work England because they don't regulate employers. Now, the SSSC do regulate employers generally, so if there was unsafe practice in an employer could be investigated. If you're working in adult social care, I would say CQC, but again, I don't think it's only just kind of come in that CQC are starting to regulate adult social care. They didn't for a while. So the experience of that, I couldn't comment on because it's very new that they've kind of come into regulating adult services. Working in children's services, Ofsted regulate children's services, so there is a regulator there. I think the only thing I would say in terms of it is difficult, and we've had this kind of frustration in the past because it feels like sometimes employers behave in a way that they really shouldn't be behaving for, but the avenues to report that or disclose that are very limited. A couple of things I would always say to people to do: if you have genuine concerns about unsafe practices, highlight what those unsafe practices are to your employer and do it in writing, because if something comes back on you that something's gone wrong, you can show that you have desperately tried to do everything you can to try and eliminate that safe practice. And I think if there are individual regulated professionals that are overseeing that unsafe practice or that unsafe system, whatever it is, and you've raised it with them and they are not kind of taken into account, you can refer individuals to Social Work England if you felt that there were really behaving in a way that was potentially putting service users at risk or members of the public at risk, for example. There is that kind of avenue to go down. Also worth perhaps getting hold of your employer's whistleblowing policy to see if it would be a valid whistleblowing complaint, because again, you can then demonstrate that you've done everything you can under their policies to raise legitimate concerns about that practice issue and the employment processes, whatever they are. Sometimes people raise collective grievances. If there's a group of staff that are concerned about it, they may want to raise a grievance together or raise the whistleblowing complaint together. But I think it might be worth ringing the A&R team to kind of talk that through a little bit more in terms of what the specific practices are and where it may be relevant to direct that to.
Thanks, Laura. Colin, anything?
No, I think that's a really good answer. I know that the person who's put the question in mentions the local government association, and I'm aware that they've got standards for employers who provide social work, but they're saying that the LGA said they didn't want to know about it. And my recollection of the standards is that the notion that it's an electronic problem. I know they do talk about safety and about safe working conditions, but I don't recall ever seeing anything about electronic systems. So it sounds as though it's pretty niche, the concern that's there, and I would agree with Laura, it probably requires an individual approach as well. So a conversation around that would probably be warranted, I think. Yeah.
Thank you. So another question for you, Colin. Having been through the fitness to practice experience, what struck me was the dishonesty of my employer to not provide requested written records after several legal requests had been made. How can this insurance for my profession and livelihood be greater protected?
Okay, thanks. Yeah. Yes, one of the things that we frequently see as we represent people is at various stages in the process, usually the investigation stage, we ourselves get quite concerned that the case gets stuck with employers having requests made of them for information and not providing the information in a timely manner. Generally speaking, they do provide it eventually, but Social Work England, all of the regulators have statutory powers to require employers to provide information, and they're always, it seems to us, quite reluctant to exercise those powers. So we find ourselves writing to them and saying, have you not got this yet, or we want you to pursue this. Have you can you please get that information? And I'm not sure if it comes to dishonesty, but it might do. There may be issues of dishonesty there in relation to what's being provided. One or two of the things that we do, we ourselves, if we're waiting for information, we'll often ask the member to make a subject access request of their employer, see if we can get the information from them that way. But yes, it is difficult. Another place where we might be able to intervene is once an investigation is complete. If it looks as though the investigation has been poorly conducted and there are still gaps in the information, at the end of an investigation, you have another opportunity to make representations, and that would be a good time for any person to say, yes, I do have representation. I don't think you've been sufficiently thorough in getting information from the employer. And it's really helpful if you can outline exactly what you mean by that. So you can say that X documents and Y documents, and I'd like to have seen some emails that I know exist and that sort of thing. And the case examiners have an opportunity when they're looking at the case. If you've made that representation, they will. I've certainly seen a number of cases where they will instruct the investigator to go back. They'll go back to the investigator and say, yes, there are gaps here. Can you please specifically find this information so that we can make a decision and a recommendation? So it is difficult. It feels very one-sided. I think it is one-sided. I think you're sitting there waiting for Social Work England to do a proper job in their investigation, and sometimes you feel as though obstacles are being put up by employers to prevent information being provided, certainly in a timely manner. So it's very frustrating. But I think the thing is I'm going to come back to the same thing really. If you've come to us and you're being represented, I would certainly I know that our team would be looking to support you to get that information as quickly as we can.
Thank you. Anything to add to that, Laura?
Just a little bit of kind of reassurance, I suppose, in terms of that protecting your professional integrity, really. As Colin said, we have had cases, and I've had one very recently, where when it's got to the case examiner stage, so at the end of the investigation, we have made representations. We've been making representations throughout about what evidence needed to be ascertained. It wasn't deemed at the investigation stage it was necessary, so we did a list of what we felt was important. And the case examiners did refer it back and said, no, we need this information. So I think it is helpful. Again, I would reiterate, get representation, because we can go through bundles and pick out bits that you might not necessarily notice that might be important, and kind of put it in a list format, kind of very formally to those investigators to make sure that goes to the case examiners. But we have seen cases come back where they've said we need this evidence in order to make an informed and fair decision. And the other one, I would say, which isn't ideal, but it does happen, is I have personally been in hearings representing our members, and issues have been raised by the panel about evidence that has been asked for repeatedly, so by myself and the member throughout an investigation, throughout the preparations for the hearing, and the employer hasn't provided it, Social Work England haven't ascertained that information, but that then has had a significant impact on the outcome of a hearing, because the panel have determined, well, if you haven't got the evidence to prove this allegation, then therefore, we can't determine that it's found, basically. So that isn't reassuring, because you don't want to have to go all the way to a hearing, and we try to challenge it all the way through. But there are things that we can try and do to try and get that evidence. Unfortunately, employers are sometimes very unreasonable at times, and need constant reminding of their duties to engage with the regulator. But we do everything we can to try and support members with that and challenge that.
Well, that follows on to our next question, which is for you, Laura, and it is about employers. So the question is, are you aware of employers conducting investigations where they take witness statements but don't call witnesses to attend to stand by those statements with our local authority employers?
Yes, unfortunately, yes, it happens far too often. Again, our team, particularly the members of our team that are representing people with employment issues, will challenge that all the way through. We'll say, we should have the right to examine witnesses, cross-examine witnesses. Sometimes we'll see employers refusing for witnesses to attend. And I think it's very difficult because there's no particular legislation that says you must do it. There's the AYSE code that says you must do a fair investigation, but it doesn't specify that you've got to have witnesses attending hearings and that kind of thing. So we tend to challenge employers from a fairness perspective, saying that everyone's entitled to a fair trial. I think what I would say is the employer may think that they've allowed their staff to kind of get away with making, for want of a better way of putting it, but kind of giving those statements and not being questioned on them. But if it goes to the regulator, if it goes to a hearing at the regulator, that won't be allowed. Hearsay evidence isn't normally allowed. If there's a witness statement and the social worker who's under investigation or at the hearing having their fitness to practice questioned, if there are witness statements provided, normally those witnesses have to attend the hearing. So again, hopefully ultimately it doesn't come to that. But there is quite a lot of difference between employment processes and regulatory processes. And there are kind of policy, the kind of procedures, regulations and legislation and case law, all that kind of thing with regulatory proceedings, which mean that if Social Work England provide a witness statement to support allegations, we have a right to cross-examine those witnesses. So in a regulatory hearing, you would see that being managed slightly differently. Employers sometimes are a little bit of a law unto themselves, but we do everything we can to challenge that.
Thanks, Laura. Colin, do you want to add anything?
Just one thing. Laura's answer was really good, and I think the point that you were making at the end, Laura, is absolutely right. One of the things that we often try and do in a situation where the employer is reluctant to call witnesses, but they've put in written information from them, is to raise within the hearing that we have concerns about that, so that there's a record of us having raised concerns, because it's feasible that internal employment hearing may have to forward their papers to an employment tribunal in due course. And I'm not saying it's going to be determinative of the outcome you get, but it's good to have it on record that you are raising concerns about the quality of the evidence that was being provided later in the process if it reaches a tribunal hearing. Vast majority of cases don't, of course, but it's always good to have that mentioned in the hearing.
Thanks, Colin. Before I go on to the next question, I just want to acknowledge some of the comments that have come into the chat. So some frustrations in terms of the limitations of whistleblowing when people have tried to action that. And also, I will summarise some of this so it's not identifiable, but just how difficult things have been in terms of a person's experience being put out of work for 9 months and returned with a fitness to practice order, following sanctions and being struck off. I'm sure these are huge issues that you've heard before, Colin.
Yeah, I mean, they are. Sorry, you mentioned whistleblowing, Callum. Was that?
Yeah, somebody's made a comment about really the hopelessness they've experienced with whistleblowing, just the limitations of it. It's clearly been ineffective when used. Yeah.
Yes, it's. Sorry, I haven't been seeing. I'm seeing some of these questions out for the first time, so I can see what you're saying now. I've only just been able to scroll down. It's very frustrating whenever you're in a situation and the whistleblowing's got quite a tight set of criterion that you've got to hit in order for it to be regarded as whistleblowing, and you've then got to prove detriment and so on. If is an action against you, you've got to prove that the action's based on the detriment because of the whistleblowing. And sometimes it's all about evidence. I think, one of the things that the new employment bill, which isn't yet published, but there is talk that it's going to make the whistleblowing process somewhat easier, somewhat more straightforward. But I sympathise with whoever's made the comment, because I've seen several, over the years, I've seen several whistleblowing issues which have not been able to progress because of the difficulties proving your case, really, the evidence basis of your case. So yes, it can be frustrating.
Yeah, I think I would just add to that, Colin, really. Oh, sorry, yeah, just to add to that, I think I completely get where that person is coming from. I think a lot of the time people try to whistleblow and end up with life potentially being more difficult for them in certain situations, and it is a tricky balance sometimes. I'm sitting here saying you have the option of whistleblowing. I'm not you in your situation at work dealing with whatever you're dealing with. And I think I would kind of guide people to your particular professional code of conduct with whatever regulator you are regulated by. Very often, well, in fact, all of the regulations will have kind of terms in there that say that you have a duty to raise concerns about safeguarding, for example. You've got a duty to protect the public. And I think it's getting that balance, because if you don't raise a concern, whether you go through a whistleblowing process, whether you just send an email, however you do it, if you don't raise it, and then something does happen, and you're one of those people referred to the regulator, how do you kind of prove that you've met your professional standards and kind of met your regulatory requirements, really? So I understand completely. I get it. I've represented members that have, for all sorts of difficulties with whistleblowing, like Colin said, things not being able to progress. I could kind of talk all day about it. And ultimately, it's got to be your professional decision. You've got to think about what it is that you want to raise and whether there is a requirement under your professional standards to raise it. And I would also say, again, if you want to or you need to, ring us, talk it through. I think it's something that sometimes I think our other team, the professional officers, sometimes kind of talk through, because it's a professional issue in terms of whether it's whistleblowing or not. But we will try and support with those conversations, really, and help people to perhaps go through that thought process about what they should be doing.
Thank you. I think that message is very clear. Some of the questions tonight are quite complex, and everyone's individual experiences at work will be complex. So the help is there, the advice is there. If you call the advice and representation team, you can discuss your circumstances on a one-to-one. Colin, I'm going to put another question to you. This one is quite interesting. So it says, I have dyslexia. I've told my manager this in supervision. We spoke about software that might help, but this never materialised and it wasn't recorded. There's not been any help provided. And now the person's being told that their reports are not up to standard. There's potential they're going on capability, and they're concerned about losing their job or being referred to the regulator.
Thanks, Callum. Well, this person's being treated really badly. I have to say, it sounds a really poor approach by the employer, doesn't it? Really, and I would definitely urge the person to call us so we can talk through what their situation is. If they're being told they're going into capability, then we really need to speak before it escalates any further. Because it's perfectly feasible they may have a disability discrimination situation, and the sooner we address that, the better, really. It actually talks about referral to you mentioned at the end, Colin, it's talking about being referred to the regulator. Well, I'm not saying that an employer wouldn't be silly enough to do that, but they certainly shouldn't be referring to the regulator at this stage. It wouldn't really meet the criterion to be referred, the employer's criterion. I would expect them to deal with things internally first if they've started a capability process off. And it is quite feasible that there is an action that the employee could take in this instance if there's been a failure to bring reasonable adjustments in, for example, and that this has then resulted in them being unable to cope with the work. So the person needs to take advice, and I would hope very much that they haven't got an employer who's got a trigger finger and holds out on the regulatory referral, because they really shouldn't be referring in this instance. So that would be my approach to that. I would urge the person to come forward and seek advice, direct advice themselves.
Good advice. Laura, anything to throw in there?
Just to say, we do see situations like this come up, unfortunately far more often than they should do. We represent members with these situations, and we are very often able to get these situations sorted out without anything progressing to any kind of fitness to practice process, by reminding the employer of their duties to an employee with dyslexia. So yeah, again, it's something we do. It's our bread and butter, I suppose, for want of a better way of putting it. So make sure that you get that advice and support from us.
Okay, very clear. Thanks. Still got questions to get through. We've got another 10 minutes. We'll try and answer them all. Keep putting your questions in the chat. So, Laura, this one I'm going to put to you. It's about a self-referral. It says I self-referred for a driving offence. It's been 4 months and I've not heard from my regulator. Does this mean that it's okay? Is there anything that I should do?
Well, with answer to the first question, I would say potentially not. It doesn't necessarily mean it's okay. It probably just means that your regulator's taking their time, as we tend to find all of the regulators do. Unfortunately, we do see quite lengthy, well, as Colin said earlier, very lengthy delays with regulation in a number of cases. It may be that they've looked at whatever driving offence it is and think, actually, it's not something we need to investigate. I don't know what the driving offence is. But actually, it may be worth, just as a follow-up, I don't know whether you've received an email or any kind of confirmation that it had been received. But I'd say probably give it another month or two. And if you don't hear anything, perhaps just check with the regulator that it has been received, and make sure you've got some kind of record of you having referred yourself. And if you can't find it, go back and say, well, I did go on the website on this day and it was referred. Just double checking, I think, that it's actually gone through to the right department, or at least making sure that you've got that proof that you did make that self-referral.
That's great. Thank you. Colin?
No, I haven't got anything to add to that. That was a really clear, and I can't think of anything to add to that one.
Okay, we've got time for a few more questions. Colin, here's one for you. It's about an employer. Someone's employer has introduced a new assessment process, and it's raised the thresholds for funding for social care support. I think this policy conflicts with codes and ethics. I'm really worried. Am I in a defensible position if a fitness to practice referral is made about me by a member of the public?
Yeah, this is something we see increasingly, people being anxious about the instructions they receive from their employers and their own feelings that it's leaving service users vulnerable and at risk. So it's not that unusual a problem, and it does create a lot of anxiety for social workers. And it's not at all uncommon for you to feel that you'll be carrying the can for what your employer's practices have kind of descended to, and for you to wonder how you can best protect yourself. What I would urge, and I think Laura touched on this earlier on in another answer, was to try and get some written record of your concerns and the fact that you've raised those concerns with your employer. You can do that in various ways. You can write directly via email expressing your concerns and saying exactly what your concerns are. You can talk about it in supervision, providing you've got the kind of supervision where you're frequently going to get accurate written notes. But it's good to have a written record about your concerns, because that would be the best evidence you could have of you having raised it as a competent professional looking to protect service users, but not having control to change things. So it's, as I say, be very persuasive evidence if you could try and find a way of getting some written evidence that you've raised those concerns, and even if you're unsuccessful, it still shows that you have done all that you could, all that was within your power to keep service users safe.
Thank you. Laura, do you want to add anything there?
No, nothing to add to that one. Thank you.
Okay. I've got a couple more that have come in that are situational. I didn't tell my employer I was sacked by my last job and failed my ASYE. Now I've been referred. I've been put on an interim order. I have good character references and I've sent these in with my reflective account. My supervisor was bullying me. Other people have noticed this too. Will I be able to prove that I was treated unfairly?
That's a very tricky one, I think, because there are clearly why you didn't put that on your application or CV. And it sounds like you've had a horrendous time. So from my personal, looking at that, I'm thinking you can kind of see why someone was worried about sharing that on their CV. And I think the problem comes down to whether the regulator would find that it had been dishonest. And I think that comes down to what questions have been asked when you've been at interview. Have you been asked if you passed your ASYE? Have you said yes? Have you been dishonest? Because actually the regulator would expect you to be forthcoming and honest with kind of answers about those situations in your employment and your ASYE. So potentially it could be very difficult if you haven't been honest, and it's then about looking at what we can do to support you to try and remediate, as it's called. That's a word that you will hear used a lot in regulatory processes. So I think, again, I would say we would really need to explore with you what information you shared, whether it was just a failure to put it on your CV, whether there was a deliberate kind of act to prevent your employer having that information, that kind of thing, to see whether or not it would meet. There's a legal test for dishonesty, so I think that would be the first thing that we'd want to kind of explore with the member a bit further, and then talk about how we would approach responding to that case and what kind of things the person could do to respond, depending on whether we felt that the dishonesty allegation was valid or not, really, and that would involve us spending quite a lot of time exploring that with the member. But it's a really tricky one, and with dishonesty allegations, I mean, with all allegations, I'd say get in touch straight away. With dishonesty allegations, don't leave it. Please get in touch for advice, because they are the allegations that people that the regulator takes the most seriously.
Okay, thank you, Laura. Very good answer. Colin, we've got one final question. I'm going to be quick. It's just come in. I'm on fitness to practice. I accepted smacking my child once on the balance of probability. The panel found that I do it regularly, which is not true. What should I do? Because I feel Social Work England want me to admit and reflect on my actions. What should I do?
It's a difficult one, Callum, insofar as I'm not quite sure where in the process they are, because it sounds as though there's been a determination already in when it says that Social Work England didn't believe me, and if that's the case and it's got through to a sanction, well, you know, a sanction's going to be the sanction. You can appeal some sanctions, but not others. I'm not sure if it's earlier in the process, and it sounds as though they're challenging the validity of the evidence against them, and that would be a bit different. If you've reached the end of the process, you've reached the end of the process. If it's closer to the beginning of the process, then you could look to challenge some of that evidence. So if there's only been one incident, I suppose what makes it more difficult is the evidence they've got in relation to where the evidence comes from.
Time now, folks. Sorry, Colin, but I think this was a really complex question. You should contact the Advice and Representation Team if you want to discuss this further. And thanks very much for joining us tonight and contributing to the Talk to SWU session.